Well, NPA top officials Nomcobo Jiba and Lawrence Mkhwebi have won a legal battle challenging a High Court ruling which struck them off the roll of advocates. The pair were placed on special leave for almost a year following damning findings against them. In 2016, the North Gauteng High Court found them unfit to hold office over their handling of high-profile cases. These cases were against former intelligence boss Richard Mdluli and former KZN Hawks head Johan Boysen. Now, the two have always maintained their innocence. All right, well, joining us here in studio to discuss the merits of the Supreme Court of Appeals ruling is our legal expert, Kabelo Siabi, and we hope to have on the phone as well the legal representative for Nomcobo Jiba, Zola Majavu. Let's start here in the studio with you, Kabelo Siabi. Firstly, good morning to you. Thank you so very much, sir, for coming in to join us here on Afro Breakfast.
Good morning to you and good morning to the viewers.
Well, you know, it's always a difficult and complex matter to know where to start. But I think just briefly, what do you make of that initial decision or ruling to remove Jiba and Mkhwebi from the advocate's role, and on the back of that now, this current ruling yesterday to bring them back to the role?
All right, I think the departure point should be to explain that an application to strike a legal practitioner, be it an advocate or an attorney, is a form of a disciplinary hearing in court. Attorneys and advocates are officers of the court. When you start off your career, you are admitted by the court. Therefore, if you misconduct yourself in the way that you do the work of an attorney or an advocate, you can be disciplined in court. You get disciplined in court when the sanction that is warranted for the type of misconduct warrants that you be removed from the role, right? Now, this is what happened in this particular case. The General Counsel of the Bar had received certain judgments in matters where Advocate Jiba and Advocate Mkhwebi had done certain things, and there had been certain criticism leveled at their conduct in those other matters. And the General Counsel of the Bar approached the Pretoria High Court with an application to have them struck off the roll because they had committed misconduct. They placed the facts before the Pretoria High Court, and the Pretoria High Court found that such conduct had been established. It then found them to be unfit to be on the roll of practitioners and consequently imposed a striking off as a sanction for the misconduct.
All right, let's bring in Zola Majavu, who is the legal representative for Nomcobo Jiba. Mr. Majavu, thank you very much for joining us on Afro Breakfast. Welcome to the show. Well, obviously, your client feeling quite vindicated then today. So what is next? I mean, to be called unfit and improper to have that legal position is quite a scathing remark, isn't it?
Good morning, to you, and good morning to the viewers. Firstly, let me start off by saying that SAB is spot on with the narrative and the background that he has painted. Yes, my client does feel vindicated because it is not nice to be called unfit because of allegations of dishonesty in improper behavior. And now that all of those judicial criticisms, the three sets of judicial criticisms, were fully ventilated in the courts, and ultimately the Supreme Court of Appeal had found that there was no merit in the suggestion of misconduct leveled at my client, at least with regard to Advocate Jiba. She is indeed feeling vindicated. What next? Obviously, the only reason why she is not at work or at office until today has been that since September 2016, when she was struck off the roll, and she gave us instructions to note an appeal, she took the view on our advice that it is best for her to ask to be placed on special leave so that she can focus on prosecuting her appeal. There was absolutely nothing stopping her in law, having noted the appeal, to report for duty, as Advocate Sean Abrahams has exactly done, in spite of the fact that his own appointment has been set aside. The legal position is if you lodge an appeal, the decision against which you are appealing is itself placed on suspension until the finalization of the appeal. So what we've done is we have authored a letter to her employer, which is the NPA, to say now that the reasons that underpinned her request to be placed on special leave have now come and gone. In the form of the favorable SCA ruling, she is tendering her services to return to work. It is then up to the employer to either accede to that request or deal with it in any manner that the employer may deem fit. But it is not a call for us to make to say she'll be at work tomorrow or the day after. But she has to, as a matter of law, tender her services and as a courtesy to her employer, because it is her who wrote to her employer in the first place asking to be placed on special leave, and the employer acceded. And when that particular reasons for that leave come to an end, we must similarly write to the employer and say, look, the reasons have now come to an end, would you consider? So that's where the issue is at the moment.
Mr. Siabi, you heard there Mr. Majavu talking about the fact that, there has to be an application then to the NPA. And I'm going to assume that it's not going to be a business as usual. How do you think the NPA will act moving forward? Do you think it will be a case of the NPA saying, what is the future of the agency? Do you think that the NPA will say, it's all right, come back to work and we carry on business as usual? I find it difficult to believe that it would be the case.
Look, the impediment that stopped Advocate Jiba from acting in a position as a Deputy National Director of Prosecution was the fact that she had been struck off the roll. And for you to hold that position, you are required to have or to be admitted as an attorney or an advocate. So that was the impediment that was stopping her from reporting from doing her work in the NPA. That impediment no longer exists. So it is up to Mr. Sean Abrams to look at that, and also for the president, by the way, to consider whether it is still desirable to continue with the inquiry that the former president had indicated may be instituted into the conduct of Advocate Jiba.
Now, this ruling has various implications, and we know that former President Jacob Zuma had, received a lot of flack and had been accused of, being protecting these two advocates. What does this ruling mean now for perceptions that President Jacob Zuma had been protecting them, and really the other cases that they'd been, and I put it in inverted commas, found guilty of, because you did explain to me that this is really it's a sort of form of disciplinary hearing. What does it mean then for those cases that they had been struck off the roll for example, the Richard Mhluli matter?
Look, the fact of the matter is that we must accept the outcome of the judgment. The judges sat and considered the merits as to whether there was any misconduct on the part of these two advocates or not. In the case of Advocate Jiba, it was found that there is no misconduct whatsoever, and the order that was given by the Pretoria High Court to strike her off the roll has been reversed. So she is back on the roll of advocates. With regard to Mr. Mkhwebi, it was found that certain of the conduct was established, that he had misconducted himself.
Right.
And a sanction of a suspension for 6 months was given for Mr. Mkhwebi.
All right,
that suspension ran from September 2016.
Let me bring you back, Mr. Majavu. Of course, the reason why the two advocates had been struck off the roll was the issue of misconduct and how they'd handled certain cases before them. Moving forward now, what exactly did the judge say in his ruling in overturning this order by the High Court? What did the judge actually say moving forward will then be the process? Because he's now overturned what had happened previously. So I'm sure in his judgment, there would have been a recourse to him as to what happens next for these two particular advocates.
Firstly, it was not one judge, it was 3 judges.
Yeah.
And the judgment was split, and there's absolutely nothing untoward that it happens all the time. But the majority decision is that of the majority of the judges who wrote that particular judgment. What was before the judges was not in terms of recourse. The issue of recourse is left to us as legal representatives to say, what now do we do to protect our clients' rights? The issue that was before the judges was, there were 3 judicial criticisms in terms of which the GCB, as custos mores of the profession, deemed it prudent to ask that they be disciplined and sanctioned. And the form of sanction they sought was a striking off, which they obtained. And aggrieved by that decision, my client then appealed to the SCA. And in considering the matter, the SCA looked at this matter afresh again, and they paid particular attention to all three original complaints that pertain to the criticisms against the respective advocates on account of their own conduct. And the judges found that, at least with reference to my own client, Advocate Jiba, no allegations of misconduct were substantiated. And therefore, the very basis on which the sanction of a striking off was imposed was baseless. So the judges, having found that misconduct was not proven, they did not even need to deal with the issue of remedy going forward, other than to reverse the striking off. The effect thereof is that my client is restored into the original position that she was. How we achieve that is a matter between me and my client's employer to deal with the optics. What remedies are available to my client as a result of the pain and suffering that she has endured as a result of this is something else that I may take instructions on if my client is so minded in that direction.
Yeah, and that's where I want to go in terms of the reputational damage. In terms of that reputational damage, what does your client, are you able to put us in confidence really to tell us what your client has said about that in terms of that reputational damage? I mean, obviously this has a retrospective effect.
If I had instructions in that regard and permission from my client to take into confidence, I would do so. But at this stage, my client is only just concentrating on restoring her life back as a professional and as an advocate. As a lawyer, I'm a creation of my client's instructions. At this stage, I do not have instructions with regard to reputational damage that may have been suffered.
All right, let's close off this conversation by bringing you back in, Mr. Siabe. I mean, he said he doesn't have that permission yet or that direction yet from his client to speak about what's to happen regarding the reputational damage. But from your analysis in a situation like this, where an advocate has been struck off the roll and then a reversal of that, what do you perceive to be or should be the recourse, or what is available to Jiba and Nomcobo at the moment?
Look, what would be available, obviously, as Mr. Majavu says, they will engage with the employer and see how to restore her to a position. That is a matter between Advocate Jiba, assisted by her lawyer, and the employer. As far as a remedy is there, it would be that you could sue for what is called malicious prosecution.
Right.
If somebody brings an action against you based on what they know is false information, you are able to go back and say, because you've tarnished me through bringing those proceedings based on a false premise, you should pay me damages that I suffered. I'm not too sure whether one would be able to show malice in this case.
All right. Okay. Well, we'll have a conversation about this later when we know exactly where to from this point. We appreciate your time very much, Mr. Kabelo Siabe. Thank you very much for coming into the studio. He's our legal expert, and thank you very much to Zola Majavu as well, who joined us there on the line, the legal representative for Nomcobo Jiba in this particular case. Well, vindication then for the two advocates at this point, as they have been brought back in to the role of advocate.